Okay.
Minister Lametti, one of the Chief Munias asked you about C-92 and that there doesn't seem to be an implementation plan for that. Which courts are going to handle child welfare cases? What is the plan? Why would you have a law come into effect on January 1st, 2020? Like, what are you guys doing to actually deal with this situation? It's going to change the paradigm around child welfare. Like, what are you doing?
Well, the point is precisely to change the paradigm, to allow Indigenous communities, First Nations, Métis, and Inuit to take care of their own kids. And each solution is going to be different. Depending on the community, it's going to be contextual. It's going to reflect the traditions of the community. So there isn't a one-size-fits-all solution to C-92. The commitment is to co-develop this across Canada with different communities as they are ready to come forward.
There are requirements that come into force on January 1st in terms of notifying First Nations when their child is in care. Being able to liaise on that, identifying Indigenous children. I mean, there's national standards now on January 1st. So what is in effect to actually address the implementation of this bill?
Well, I think the other piece, Jorge, is that the nations themselves are going to be working on their child well-being laws and to be able to implement their laws such that then the Indian Act no longer applies to that nation. So that Section 88 of the Indian Act is exactly what we're trying to get around. Laws of general application. We're saying no, nations have the jurisdiction to look after their own kids, to keep their families together, to bring their kids home, that this is the way we're going. This is about the rights and well-being of Indigenous children and youth, and that is protected when they have a secure personal cultural identity, when it isn't about the money going to lawyers to apprehend children, to agencies and non-Indigenous foster families. This is a whole transformation where the money will go to kids and families and communities, and that is the implementation that will be directed by the nations themselves. This morning was a very interesting meeting with the Yukon government and the Yukon First Nations in how they are going to work together to implement this themselves. So this will be done region by region, but it is a clear signal that it has to stop. This approach, as the minister said, about apprehension has to change to prevention. We can't be apprehending kids because their parents are poor. I think Cindy Blackstock taught us that a long time ago, that you shouldn't be able to apprehend children just because the parents are poor. And so we want to move on the poverty reduction. We want to move on self-determination. But this is about the same as the TRC. This is about the child that was taken, the family left behind. It's no different, and we have got to start now working with the First Nations to make this happen.
With the talks that you're entering into on the child welfare compensation, are you seeking a consent order with your partners to agree that this tribunal order will go away and that you will enter into a settlement?
We're going to leave that. Minister Miller said yesterday the steps that he was beginning. We're going to be supportive. We're going to listen throughout the process. Our point from the beginning was that we accepted the decision about liability in the first ruling, and that we would move forward to a comprehensive and fair settlement that was fair to all kids and families and their unique stories. And Minister Miller will push forward in that regard.
So are you seeking a consent order or not?
I'm not going to say what we're not doing. I'm going to leave that to Minister Miller's lead, and what I can do as Minister of Justice and Attorney General is to work with First Nations, with my colleagues, with groups like the Assembly of First Nations, to try to make sure we're moving forward in good faith on finding the right solution.
And I think what we heard from a lot of the families with the parallel or the 60 scoop, that when Chief Marcia Brown came out after having won the court case, she had this list of things that she wanted in terms of access to healing, language and culture, all of those things. And so as part of the agreement with the 60 scoop survivors, there's now a foundation where those families can get access to healing, dollars for language and culture. So this is about a comprehensive approach to harm that was done, and that we want to do it in the best possible way. And Minister Miller is going to do that with the support of Minister Lametti.
Minister Miller, can you just, Minister Lametti rather, as a lawyer, can you just spell out the legal concerns that the government has over this tribunal ruling and the precedent that it could set?
Well, I'd rather not go into great detail on that. We have raised legal concerns with the case. The only one I'll cite is that you need a mechanism that allows individual children and their families to tell their stories and to be compensated accordingly. There isn't a one-size-fits-all solution, and so we need to move forward with a more sensitively tailored solution to the problem.
Do you feel that the tribunal will say no to you if you brought up a plan that expanded what the tribunal's ruling was? Do you think the tribunal would say no?
I expect everybody. I know Minister Miller would, I think, agree, but I expect everyone. We expect everyone to sit down in good faith and try to get to a fair and comprehensive settlement here. I know that the history of colonialism in Canada will lead some to be skeptical about that. But I think I would point to the fact that our government over the last 4 years has done great work on implementing Jordan's Principle. We're up over 470,000 applications approved. We've increased the funding to meet those kinds of real needs that kids have and that families have. So I think we're moving forward in the right direction, notwithstanding a frankly checkered history. I think we've done great work in the last 4 years. We're not perfect, but we're moving it forward. We're going to sit down in good faith, and I think we hope everybody will sit down in good faith. We're talking about kids. We want to help those kids. We want to help those families, and we're going to push forward on that.
It's been 6 months since the inquiry released its findings. Minister Bennett, you noted June is kind of a target, if you will, and that it's going to be a living document. Can you just provide an update on the status of the action plan, and especially, a lot of people are looking for answers about where things are at now?
Thank you for the question, and I was very pleased to be invited by Minister Monsef yesterday to the FPT meeting on status of women ministers with the Indigenous leadership of the Women's Council from the AFN, but also Patutik, ITK, as well as the Michif women. And yesterday morning, I think we had a full morning to begin that work. Really, since June, the department has been reaching out to the organizations, provinces and territories. One of the things that everybody agrees to is that we actually need to identify the wise practices and promising practices that are actually working, and make sure that a national action plan is built around those things that are working, as well as to know that there is a commitment to co-develop it, and that we need our partners to describe what that would look like in order for us to not be reinventing the wheel, but actually acting on what the Commission asked us to do, but also to know that at the anniversary of the release of the Commission's report, that there is an outline and a document that people agree with that will have to be built on, but the idea that it be distinctions-based and regionally sensitive, culturally sensitive, trauma-informed, these are all the principles that will have to feed into a national action plan.
Why does it have to be such an involved process? I mean, there were lots of people who waited for the inquiry to complete its work, and then when you said an action plan, they kind of thought there might be a specific action taken. And I appreciate you're saying there's work going on across governments, but for those that want to see something concrete, waiting until next June to see an action plan might not be the answer they're looking for. So what do you say to them?
We say that we haven't waited even for the commission, and whether it's as the minister talked about, the family liaison units that are really working well. Tonight there'll be a screening of Audrey's story. The FILU or the Family Liaison Unit from Ontario have commissioned a documentary that is this amazing story of a family that just wouldn't let up, and eventually the Chief Coroner of Ontario has reopened the case. So these are really important work, coast to coast to coast, but it is about building an action plan bottom up, making sure there are the resources for commemoration, for shelters, for all of the things that we need. There's 231 calls for justice. We believe we've got to have something in the window by June, but we're not waiting for that we are doing exactly what our partners are asking us to do in this time frame, and in the distinctions-based approach. The AFN will reach out to their partners, the MNC and the Métis, as well as ITK and Potutic. But the federal ministers the provincial ministers were amazing yesterday. There was this presentation called Path Forward in terms of the community safety plans in each community in British Columbia that Elaine Alec delivered. It's so comprehensive, it's so good, and it's so respectful in terms of building the real solutions bottom up.
Mr. Bennett, has Canada or is Canada providing any advice to the U.S. for its own task force on missing and murdered Indigenous women?
That's a very good question, and I will. It'll be interesting to find out. I know. I think the OAS people are here this week, but also I think we will find out from Minister Freeland and maybe all of our counterparts to find out if that is the case. As you know, there was a trilateral process, the NALS process, which was Canada, the U.S. and Mexico, that has been meeting twice a year to deal with the issue of violence against Indigenous women and girls. And so, again, as we come back to work, we'll find the status of those. But that was an area where there were wise practices identified, and I think even the Native Women's Association of Canada really felt that they'd learned something about safe houses from the Mexicans. So, I think in our big country that sometimes we end up with urban solutions when it is from other countries, that we can even learn how things can be done better in the rural and remote areas, because the kind of women's shelter that is anonymous, invisible in downtown Toronto is not appropriate in so many of these small communities where everybody knows where it is, and women do not feel safe.
We have time for one last question.
Mr. Lametti, a number of the calls to justice had to do with the justice system, and yesterday we heard National Chief Delgar call for more restorative justice to be used when it comes to Indigenous and First Nations. Is that something that you're looking at as a response to the inquiry?
Yes, as a response to the inquiry, and yes, generally. I firmly believe in restorative justice. Restorative justice programs work. There are a number of pilot projects that have been implemented, particularly in Indigenous settings, and they're very sensitive. They're very sensitive to culture. They're very sensitive to Indigenous legal traditions and practices. So the more that we can do there, the better it is, particularly because it will keep communities whole, keep people out of the criminal justice system, which is heavy-handed. And so, yes, and I'll do my best to continue to push for more resources for restorative justice programs across Canada.
We'll support you. I just wanted to say that I think that the kind of work that we've seen from Chief Bilo at Alkali First Nation, or the kinds of things that are restorative justice, there are models already working that we need to learn from, and that for any of us to go into a women's prison and see all those mothers there who were never sentenced to jail, they're there on breaches, and all their kids are in care. That we know this has to change, and we have the commitment, and we're gonna we know that there needs to be resources there, and that I think for a lot of us is a priority.
Minister Lametti, can you just respond to a question from my colleagues in Montreal? They want to know if you're concerned over Premier Legault's comments on the Bill 21 challenge that calls into question the independence of Quebec's top judge.
We we have said from the outset as a government that we would follow what happened in the courts very carefully. We are continuing to do that. I won't say more than that about the
Legault
process.
Crossing a line?
I won't. I won't say more than that. We're following the situation. We're following the case very closely for obvious reasons. It touches upon the fundamental rights of people. The Prime Minister has said that he disagrees with the law personally, and so we are at this stage we are at this stage following the procedure for the stay. And we'll follow the procedure through the superior courts, and we'll continue to monitor.
Thank you all. Thanks so much.
Just a quick word on the UNDRIP co-development. Like, when is it going to start? Like, who's going to be involved? Just something quick, just to add some meat to your announcement.
Well, Minister Lametti and I will work together on this. I think that we know that we're not starting from scratch, that from Romeo Saganash's bill to Bill 41 in BC, that there are building blocks there, but I think that we also know that a Made in Canada approach, where there are all of the languages, distinctions based, that there's going to, I think it'll be exciting to work with our partners to get it right.